Good afternoon, folks. Welcome to another Hill and Ponton Q&A live on VA benefits. Today it's just me, so hopefully you bear with me and I can get the questions you have, and when possible, I will give the Carol Ponton answer in addition to mine. First, though, I'd like to take a moment to pause. The veterans community had an unfortunate loss this week. Combat Craig, as many of you I know you know, passed away. He had an accident and he died 2 days ago. I got to know him, Louis is his real name, well over the years. We did a lot of videos together. I actually went out to his house in Idaho one time and got to film with him in the Combat Craig bunker. He was a great guy. He always kept me on my toes. Whenever we did our interviews, I never knew what he was going to ask. I never knew when he was going to throw one of his crazy jokes in. Getting to see his lair where he worked was really cool. He just had this ordinary house, and then you open the door to the basement, and it was just like a different world down there as far as all of his collection of random stuff. And he has a video setup that I still envy. It was just so amazing. So it's a big loss. He was a great voice as an advocate for veterans. He was so transparent, put himself out there for the world as an example of what a hardship is going through this whole process, yet keeping with it what you can get in the way of benefits you deserve. And then he didn't just settle there. He turned around and helped hundreds, if not thousands, of other veterans. So he's really special, and it's a loss to this community. With that and a heavy heart, let's go ahead and take some questions. Charlie, part one. Previously received 80% and was eligible for TDIU and had indicated in my lay statements about unemployability, but did not submit. Just received 90, and this time VA sent a letter stating if I wish to claim TDIU per my lay statement, then respond within 30 days. Should I include treatment records that were already provided for conditions that VA service connected for me? They just approved me for migraines secondary to anxiety. And I provided a Nexus and DBQ for my local treating neurologist. Do I need to submit the same documents again? So there's the do you need to or should you? You don't need to. They're already part of your file. You can double check this by looking at the last grading decision to make sure they were mentioned there under the evidence section. I would pull out parts, like 1 or 2 pages of a medical record, maybe the heart of the Nexus, and attach those and say, hey, these are just pages to documents to medical records that have already been submitted, but they cut to the heart of the matter as far as the IU. And I would go there. I couldn't tell if you were asking kind of about an effective date issue, but from what I'm seeing, this should go back to the date you at least received 90%. If that 90% was within a year that you received 80%, then it should go all the way back then as well if you were not working at the beginning of that time. So wouldn't submit everything total, but maybe just pick out the pieces that you think are the most important and put those on there. Nathan, hello, just had CMP for neck increase, currently 10%, back 20%, both worse now. Claimed upper radiculopathy second to my neck strain, cervical stenosis diagnosis. Got upper radiculopathy diagnosis earlier this year. Is this an easy claim to win? I have mild symptoms in right arm and moderate to severe radiculopathy in the left arm. What are average bilateral ratings for each arm for these? 20%, thanks. Go back to the first part. Let me just make sure I understand what service connection is for. Okay, so neck is at 10, back is at, so we're saying this is secondary to the neck strain. Is this easy to get? I mean, I consider this pretty straightforward medicine. If you have radiculopathy in your upper back and you are already service connected for your neck, unless there's some kind of nerve impingement in your shoulder, that's most likely the cause, so that should be service connected. As far as the ratings, if it's mild, 10%, moderate, I think it's in the second slide or second part of the question. Let me see where he is. Mild, moderate to severe. So moderate to severe could be 40%. When I see severe, I'm wondering if there's loss of use of arm. And by that, I mean, have you had to significantly change how you're using your hand, how you're using your fingers, dexterity to get around. Did you used to hold a pen like this and now you got to hold it like this to draw? Did you eat like this with a fork and now again you hold it like that, or you have to use your other hand to steady it? Or being your non-dominant hand is that, look at this, folks.
I can't hear you.
She can't hear us. Well, that's even better. Carol can't hear us, but she just joined in, unexpected to me. So that's great. We can hear her. She can't hear us.
Hello.
Benji,
can you hear me?
We can hear you. Benji, yeah, can you take her backstage and maybe help her on that? So yeah, if I see severe radiculopathy, I'm thinking at least 40%, but then I'm also going for loss of use on that. So I'd say 10 to 20 for your other one, and then it should be 20 to 40 for the right arm. All right, can you take me the next question? Channel of Love, Hope, and Faith. I love it. 1 and 2. At 62, received 100% SMCS, mental health, 100%, headaches 50, tinnitus 10, GERD 100. Wow, cancer-free now. All right, Carol, can you hear us this time?
I can this time.
Right, so Carol joined us. That's great. A surprise here. Let's go back to the first part of this question. First, Carol, how are you doing today?
I'm great. How are you?
Great. Haven't seen you in a while. Looks like it's cold out there in California. You got a jacket on?
It is. Can't beat it.
Not a fan of the heat, that one. All right. Well, we just started. I think I just did one question, and now we are on to Channel of Love, Hope, and Faith. So 62, received 100% P&T, SMCS, mental health 100%, headaches 50, tinnitus 10, GERD cancer 100, cancer-free now. Will they reopen the GERD even if they won't? It won't affect my overall rating. If they do, am I subject to review on all ratings? Not subject to review on all ratings. If you had 100% for cancer, that will drop to 0, and then they will rate the residuals of that cancer. So those will be reopened because that was not a permanent rating. Carol, any other thoughts on that?
Well, I wondered what cancer do you have so that we could see if, there's things we suggest that you start complaining about that are the residuals.
Yeah, and then the other thing Carol would go for is if he's got 100% for mental health, he's already SMCS. What are you looking at?
Aid and attendance.
Yeah.
So
there's that possibility there. All right, what do we got next? AW, hello. How can we get the M21-1 updated so raters will grant SMCT in accordance with last year? So the process, and I don't know that this isn't in there, but the process is they have the central office review the court cases that are precedential that come out, and they release these things that are called DADs. It's like decision assessment document, and then those get associated with M21. This takes, as you would imagine, forever to get in there. And I got to say, it might be in there and they're just not using it yet because they don't understand it. But I don't know. So it's that's the process. I don't know what the time frames are though.
But I think the problem is you're not going to get a rater to give you SMCT unless it's just amazing, because usually you have to go to the board and sometimes the CAVC. I don't know why, but they don't like to give that rating. I've never gotten one from them. It's always been from the board. Yeah,
I think we've gotten a couple in our firm from the RO, but it is so rare because I mean you're talking about over $10,000 a month, and they don't, in the VA world, if you make a mistake against the veteran, that's okay. If you make a mistake for the veteran, they get penalized for that. How's that aligning incentives? So yeah, let us know when you see it, and obviously if we see it, we'll let you know. But I agree with Carol, even though it's in there, that's a board case.
So in other words, don't linger at the regional office. If they denied you and you feel like you have the evidence, going to the board.
Yeah, I agree. All right. Navarre Nay, one of two, filing higher level review for vet injured in April 75 while on active duty in Germany. Vet got help Dallas VA beginning of 76 through present. VA says they only see records from 2003. Doctor's notes from 2003 refer to MRI 10 to 15 years ago that identified herniated disc. We get to submit a statement pointing out errors. Is there a form for this statement? Yeah, the 4138 is the form you would submit for anything with the VA. I don't know, what are your thoughts on this, Carol?
Well, they don't have a form, but like Matt said, we use 4138 to point out errors. Probably those notes have been sent to the St. Louis record keeping office, and you're going to have to go there to get them.
Even if they were VA records?
Yeah, the VA, I found that unless you continuously get treatment at some place, and so they should be there, but if they're not there, I have a feeling that for some reason paper records were sent. I don't know, but that's the other place they would be.
Okay.
And I assume you've gone through your claim file and also asked for your military personnel record. That it may be in there. You don't know. The claim shop file should have picked those up over the years.
Yeah, I don't know. Yeah, they're not allowed to destroy them. You know, it's not like a normal physician that can get rid of them after whatever it is, 5 to 7 years.
Right. So they're probably in St. Louis if they're not at that office, at that VA.
And I'm sorry, let's go back to that last one. One more thing. Let's say that they did lose the records. What I would say is this is what happened in service, because I think we have an incident in service that they're not contesting. And you can write in that statement, I have treated since I got out of service for this disability. It's not gotten better, it's the same, or it's gotten worse. And you know, you can put a statement in there. And if you have a loved one that could say the same, you know, he came out of service and he had this bad back, have them say that as well. So that's a way to circumnavigate the loss of records if you have to do that. Clay JC, help 1 or 2. I received 100% P&T, but 3 months later, the VA rescinded the service connection for anxiety due to VAQ and I owe $9K. I stayed 100% P&T due to recent approved back claim. I have no other mental health claims, only musculoskeletal claims. Should I appeal the service connected Q for anxiety so I have backup in case something else is reduced?
Can we go back to 1? Just received 100% permanent total, but 3 months later, VA rescinded Social Security for anxiety due to a VAQ and I owe 9. You can't owe 9. I mean, that was their mistake. You definitely don't owe that. I stayed at 100% due to a recent approved back claim. The VA, and I've been trying to talk about this, they have, it started the first of these this year a lot, and then it has stopped, but they have been doing a lot of Q, clear and unmistakable error, having things severed or reduced. And almost, I think every single one of ours, they were wrong. So we went to the board. The regional office may help if you file a higher level review, but I think you should file, if it's too late to appeal that, I think you should file an appeal of that to the board. Hopefully you can go there and show this was not Q, that this was a valid finding, and that the clear and unmistakable error was on the VA had to show there was a clear and unmistakable error, not me. And I think that it will restore that for you. You have nothing to lose, so I would definitely file that. Every time they've done that, they've been wrong that I've seen.
Yeah, I agree. They try to use it the same standard that you have to show when you're showing service connection.
In other words, to be clear, once the VA has made a decision, in order to change that decision, if you've gotten beyond the appeal time, is to show there was clear and unmistakable error. So you go back to when the decision was made and only look at the evidence as of that time. But once you are granted benefits, it's on the government's part to show there was clear and unmistakable error. What they do is try to make you show that there was clear and unmistakable error. And they will, sometimes you can get it reversed to the regional office. Most of the time you have to go to the board, and every single time they've reversed it that I've had.
Yeah. And then I'm trying to print out, I just did a quick search on this as far as them trying to recoup it from you. Benji, if you could, well, I don't know if that's going to.
I assume they didn't continue to try to recoup it.
It sounds like it's in the middle of the process right now. But Benji, this is the waiver of overpayment. That's what you want to ask for, is a waiver of overpayment. And then you basically got to show that you were completely not at fault, and that this would be an undue burden on you to have to pay them back for the error they made. So I would be arguing that along with the Q. I agree with Carol. I think you will win on the Q grounds, but this is kind of a just in case argument. And I don't know that, yeah, I mean, I'd want that anxiety to be service connected so that you can get SMCS.
Right.
If you have both those 100%, then you get that extra bump of whatever it is, $300 a month. So, you know, I would go for that. So that's kind of my thought.
I think the VA really made an effort to try to scare veterans, to make them stop filing claims, stop appealing claims. And they really had a lot of, I got a huge number of severances, reductions, and they've stopped that pretty much. But the first of this year, I was flooded with them, and now they pretty much stopped it. And like I said, I appealed every one of them, and we won every single one of them. So hopefully these aren't continuing.
JRH 1 and 2. Hello, I have SMC-M for loss of use of hands requiring ANA. I also have several separate ratings of 70, 60, 50, 30 in SMC-K. None of these other ratings require AMA. Is there a path to R1? So if so, how do I apply? All right, so go back to the first part. Is there a path to R1?
I think you appeal for a higher level SMC, because all you have to do is go up to, let's see, I don't know if you can, so M half would be, okay, the IBD and the mental will take you up to N, and now you get to O. You've got M and a half, but you're not at O.
I think you
if you get to O, then that would be R1.
So we need another
get your migraines up to 50%, and you've got O, which automatically, in this case, because you have 8 attendance, gives you R1.
That's some crazy math. That was when I dropped out of math, is when math changed from numbers to letters. It's got over my head, and that's kind of how I feel with SMCs. But yeah, I think she's right. Let's focus on that migraines. Get you to 50.
Next question, Benji.
AW. In my husband's C&P exam, the examiner states, veteran has TBI and residuals. He requires regular aid and attendance. Without regular aid and attendance, he would need hospitalization or a nursing home. He does not need R2. The rater said SMCL is continued, but there is nothing in the record to support higher. Yeah, this is what Carol was saying. Even if they have the Alaska case, everything is present for SMCT. I agree. It is current at HLR after first HLR found due to assist and then supplemental denied. The denial states CFIR higher level of care to deny. Yeah, you need to go to the board. I mean, I know you're already at HLR. Maybe, please get back to us, especially if they do say, they granted it the RO. That would be great information for all of us to know. But I agree with Carol. Your case is too important, and they don't know what they're doing when it comes to SMCs.
See, a lot of the examiners don't understand how it works, like Matt said, and they think, well, you don't, because R2 usually requires that you need some kind of particular medical treatment that can only be given by a doctor or a medical provider. SMCT does not require that. He or she has stated exactly what you need to be certified for SMCT. Go for it.
Yeah, and that nonsense, it looks like that the doctor put on not qualifying for R2, that's just gibberish that doesn't have any relevance on your case. So yeah, anyway, to the board. Tiny, good to see you. Hello, I have pre-existing mental health conditions, which I indicated during my medical exam prior to entering military. I encountered MST while serving, and I filed for PTSD after discharge. I filed an aggravation. I had 2 C&P exams.
Yeah, we see that borderline.
Other examiner said PTSD not due to MST. I have markers for depression in my military records. What is missing in my claim, since I mentioned my condition prior to service and that there are these markers? Also, my VA psychologist wrote a Nexus to link my PTSD due to MST.
First question I have is, when you win it, remember you can have a pre-existing condition, but if it doesn't have any current symptoms, then you're sound, okay? So just because you had it doesn't mean that they should use that to deny or reduce any mental claim of benefits that you're entitled to, number one. Number two, it looks like to me, if you've got your VA psychologist behind you, I go to the board. What do you think, Matt?
Yeah, I mean, to kind of restate what Carol just said, you need to go back and look at your service records. If you indicated you had a mental health condition coming into service, that's part one. But part two is what symptomatology was associated with that mental health condition when you were entering service. So they would have to document that, because if it states in there a history of mental health condition, that doesn't count as a pre-existing condition. And so an easy kind of analogy of this is we see this all the time. A guy blows out his knee, has a reconstructive surgery on his knee before he gets into service. It's noted on there that he blew out his ACL, but it's a past injury. He has a history of that, and there are no current symptoms that existed prior to service for service-connected compensation benefits. So that's the big thing you need to look for here. Otherwise, I gotta say that.
You know how we identify there are certain things that we know are wrong. You can just look at the decision and see that. Pre-existing conditions, I would say 85 to 90% of the time are wrong. They aren't really pre-existing conditions. That's how often the VA gets it wrong.
And that's huge, because you have markers of depression in service, and that makes it a lot easier to prove.
Exactly.
So yeah, I would definitely check on that first. And that
I don't think you're going to get your way at the regional office, Matt.
Yeah. And I apologize for that C&P examiner. That person is a piece of crap as far as I'm concerned to say you have PTSD. No, seriously. I mean, that's just
I agree.
Going out.
No, I agree.
Mindful. That just makes me angry. Okay. Good luck to you, Tiny. Please get back to us and let us know how that goes. Count the cost, 1 to 5. I'm currently rated 100% permanent total. Service connected to the following: 70% depressive disorder due to chronic pain with major depressive-like episodes, including symptoms such as sleep disturbance and anxiety. 60% for upper bilateral extremities, 50 sleep apnea, 50 migraines, 40 lower back, 40 lower bilateral extremities, 30 for cervical spine, 20 beat knees, 10 GERD, 10 tinnitus, 10 hypertension, 10 AFib. I'm considering filing for 100% P&T based on TDIU using my depressive disorder in order to qualify for special monthly compensation. Could you please advise on how I should proceed? Thank you, Helen Pond team. Your live streams have been instrumental in helping me achieve 100% rating. Thank you for that. I think Carol has much higher aspirations than than 100% P&Cs. All right, go for it, Carol.
Okay. Number one, you're going to file for unemployability solely due to your mental condition. And what you need is you need a nexus letter. Maybe you have a VA psychologist who can say that you just need to get a DBQ, Disability Benefits Questionnaire. And when they ask, remember, the most important things are, the first thing is they'll diagnose you with PTSD, and then they will, not much farther down, it says, how does this limit you? And what you want is total disability, if they will. If not, the next one up, deficiencies in most areas. And then near the bottom, they have symptoms, and that's what's really important. Look for the symptoms you need either for 100% or to keep you from working. A lot of times, not being able to be emotionally stable, not being able to work with bosses or employees. Those are the things that would keep you from working. So I think that should be relatively easy for you to get. But what you want is you want aid and attendance, and you want aid and attendance solely for the mental condition if you can get it. And then you can use all of these other things. Now, the problem is, I think the mental condition.
Go back to the ratings, the big ratings, not the 10. I was just saying, go back. There they are. I just want you. I mean, what jumps out to me, 60% bilateral upper, is that
loss of use of?
Yeah.
Okay, but here, go back to the very first one, Benji, if you would. It says permanent and total for depressive disorder due to chronic pain. Okay, so that, what I want to do is make sure that the mental is not encapsulating all of the physical problems as well, because then if we use that for aid and attendance, that's going to disqualify you for using it to get higher up the SMC going toward R1. So can you show me the next one?
Yeah.
So like what Matt was talking about, if you have 60% for bilateral upper extremities, you probably have loss of use of hands, okay? So in looking down here, you have 40% for your lower. That could be loss of use of feet.
They don't give those away easily. That's I
No.
mean, we when we see them those ratings, that's a indication to us that
So you're going to file for aid and attendance. You're going to file for loss of use of hands, loss of use of feet, because what you are entitled to, I think, is R1. But you need to be sure how you qualify that. If you get aid and attendance for all of these problems, then you're not going to get to go up the ladder. Okay, so you want to get aid and attendance for one that doesn't incorporate the other things. So, like, I think I'd take the upper extremities. I think that's what would you take, Matt?
Yeah, that's what when I was reading that, that's what jumped out to me. Frankly, I'm surprised you didn't interrupt and start saying that from there. Very reserved.
I'm on my good behavior.
Good. So yeah, I agree with Carol. That upper bilateral, I'd want to dig in more to that. See
Yeah. So you SMCS is the least of what you're entitled to.
Yeah, that's just the starting point, right? It's table stakes. You should be a lot higher. All right, Navari again, if there's proof that vet filed disability within 6 years of discharge, is it wrong for CMP's person to opine that vet more likely than not had injured himself some other way?
That's total speculation. That's not valid.
Therefore denied. 1975, vet hurt left shoulder, but medic noted right shoulder. If left shoulder is really in bad shape, but right shoulder just pain, should we attempt to correct the record? Will this delay the claim?
I don't think you can correct the record. I think what you can do is do a statement yourself and someone who knew you at the time. So you want to show that this is the arm that was injured, and then you're going to claim service connection for the other arm because you've overused it because of the service connected arm.
Yeah.
You can't really correct those records that far back. You can just get witnesses to say what really happened. And people make mistakes when they put in left, right.
Yeah. Darwin, part 1. Hello, Carol and Matt. I don't know if you remember me. It was a podcast on 5/21/25 at 12:54, rated 100% TDIU, 70% PTSD, 10 tinnitus, 0 hearing loss. I filed for ANA, 10 other conditions, intent to file 16 August 24. I didn't file for PTSD increase, but VA scheduled exam for PTSD on the 8th of August. Why poke the bear at 55, rated 100% with PTSD and TDIU, dated 6 November 20, only months away from being locked in. After watching your podcast 2 years ago, you educated me on SMC. I adapted the attitude.
Good for you. I served, I deserved. That's my new motto.
Oh, boy.
You served, you deserve.
Well, Darwin, I don't quite remember the question, but I'm going to remember you now because she's going to be walking around like a maniac saying, hey, you served, you deserve. She's going to make a little rhyme out of it. But okay, Darwin, that is a good one, though. And I'm glad you poked the bear. VA awarded SMC-L based on the PTSD exam without submission of a 2680.
Very good. So
life changer. I submitted all claims: Meniere's, sleep apnea, CFS, hypertension, diabetes, migraines, lumbar back. Oh my gosh. Urinary incontinence, anatomical impairment, and ED. Okay. Thank you for giving me the knowledge and courage. My sister, a Marine vet, is inspired by you and has found courage to come forward with her MST and to file a claim. Keep doing God's work. God bless you. Well,
so
Darwin,
good
thank you for that. And I'm glad to hear your sister is going forward. That's such a hard claim, but it's something that was done.
But
to her.
it
Needs to be compensated for that.
Those claims make me so angry because they are the worst thing you can do to somebody, because it's not only a horrible thing, but then the way that the service covers it up and makes you feel like there's something wrong with you. So you tell your sister to go for it. If she doesn't get it, call me. And I wonder if you're entitled to more up the SMC.
Yeah, I want to see, Darwin. You said you put those claims in.
Yeah.
They have not been decided yet. Please get us back to us and let us know what they decide, because I think you should be climbing up the SMC ladder.
You served, you deserve. I love that. Oh, I got a new phrase.
I'm going to hear that the rest
File
of
the claim, and you served, you deserve.
She's going to get damn
Thank you,
t-shirts.
Darwin.
All right. Oh, by the way, are we doing a Carol's Corner?
We are.
All right, let's do that before we get to JDH.
Okay, this isn't anything new, but what I try to do is also talk to you about questions I repeatedly get from my clients. So I realize not everybody knows this. And I'm constantly asked, what happens to my wife or my spouse if something happens to me? So I want to go over again the benefits that are available for your spouse. And with the VA, it's never easy. But there's two different ways that your spouse will get benefits. One If you have been 100% permanent and total for 10 years, it's automatic. All they have to do is file the claim. The other way is if a service-connected problem caused or contributed to a death, they're entitled to benefits, okay? And then there are two types of disability benefits for the spouse. One, and I don't know exactly, I'm thinking it's like $1,600 a month, is just as you prove that you were 100% disabled for 10 years or that a service-connected disability caused your death. The other one is for, are you ready for this? A veteran who has been 100% permanent and total for 8 years and married for at least 8 years. And then they get a bump up in the amount they get that I think is close to $2,000 a month. Okay. So those are the benefits you get. And then
not
there's
the bump up the total.
Yeah. That's what they get. They're two different amounts depending on whether you meet the first test or the second. And then the second thing that I learned not too many years ago is, say you have a dependent child. So you have a dependent wife, so she's now a widow, but you also have a child who is disabled before they reach the age of 18. That child is also entitled to benefits, but on their own account. So you don't file under the widow or the widower, you file under the child himself, and they're entitled to $1,500 or $1,600 or whatever it is on their own. Okay, and that's a big benefit for them. Otherwise, if say that the child was just young, they'd only be getting a couple $100 a month. So that's the other thing that I hadn't known until a few years ago that you want to make sure that you follow up with. That's it for today.
Well, I just to kind of parse that out some more, because this is something advocates I don't feel like fully understand. What Carol said, most people when they're applying for, they call them widows benefits, but DIC benefits, they're applying because the vet died of a service-connected disability. But what she said, the one way is if the veteran is 100% or TDIU for 10 years for any disability, let's say they're 100% for mental health for 10 years, and they get some kind of cancer that has nothing to do with service and they die, well, you're still entitled to those benefits. And then the other thing that I find to be a nuance that a lot of people miss is if it was responsible for killing the veteran, the language is it's a direct or contributory cause of the veteran's death. So a lot of times we see this and it's like the veteran died of a heart attack, which was never service connected, but they had hypertension or diabetes. And what you need to show is that even though that's not on the coroner's report as cause of death, the diabetes or the hypertension, but those contributed to his death. Or we see the same thing, like the vet dies of a heart attack and he has PTSD. Well, PTSD unfortunately can aggravate a heart condition. So there's a lot of nuance when it comes to DIC, and I frankly see a lot of practitioners who do not appreciate this, but it's a really, really interesting way to get a benefits. I think some of the most interesting cases I've had were this. I had one case where a veteran died of he died of cirrhosis of the liver, but somehow it was like fatty cirrhosis, and he had PTSD. He wasn't a drinker. And then there was a medical record that said, but for his PTSD, he would have been eligible for a liver transplant. But since he was not medicated, he was so unpredictable, they weren't going to use a liver on him because they thought there were other people that merited it. So we were able to get the wife benefits on that because the PTSD the service-connected PTSD prevented the transplant. So anyway, those are lots of interesting cases, and I found that you can be really creative in those. So, widows deserve their benefits as well, and it's important to make sure that they're set up for that.
And what Matt said that I want to make sure we emphasize is, say the veteran was only service connected for PTSD, but he died of a heart attack. Well, you can file for any reason. You're not limited to what he was service connected for at the time of death. If you can prove that what he died of contributed or caused to his death was or should have been service connected, then you win. Okay. The other thing, and just so you know, in our office, if you have been our client and we've represented you and you die, we automatically will file the widow or widower's claim free. If they win on the initial claim, we don't charge any fee, because I know from my friends, when your husband or your wife dies, this is a very difficult time for you. And the last thing you need to do is be able to handle something like this. So this is what we do for our clients. But the other thing that is interesting is a lot of times the VA will send you a crazy letter that says you're not entitled to DIC benefits or accrued benefits. Accrued benefits are the benefits that the widow or widower will be entitled to as part of the ongoing claim that the veteran had at the time of their death. So those benefits might end at the time of the veteran's death, but say you had a claim for PTSD back 4 years. If you win that, then the widower gets those benefits. Those are what's called an accrued claim, okay? So make sure when you if you file a claim for benefits, make sure your claim is evaluated, not just sort of denied without any evaluation. A lot of those claims we find are open. So if you have questions about them, get with us, okay? Don't give them up. These are great benefits for you.
All right, and that's Carol's corner. JDH 18702. Always great info, thanks. I'm 74 years old. I have an intent to file entered since March. I got approved for tinnitus, 0 for hearing loss. Worked on Flightline for 3.5 years. I have vertigo with ongoing testing for Meniere's, filing secondary to tinnitus. I have anxiety secondary to tinnitus and hypertension secondary to anxiety. Then CAD secondary to hypertension and ED from anxiety meds. Carol always says, file all your claims at once. I'm considering filing them all at once and send the documentation for anxiety and vertigo Meniere's first. I think others will be denied, and I have a year to file supplementals, each keeping the ITF.
No, you don't.
Hold on. You are being patient. We're going to read the whole thing first.
All right.
Does the same RSVR handle all claims submitted at once, or would they send the developed ones for C&P exams, deny the undeveloped ones? Would this slow developed claims down even more? Okay, Carol, jump in. Go back to 3 of 5.
Okay. Always file all your claims at once. This does not hurt you. I tell my clients, I'm going to file these claims and you will be denied for a bunch of these. Don't worry about it. What we're saving is the onset date for payment. When you file an intent to file a claim, the next claim you file is the one that gets that date. If you
go to the next part here. That's a really important question. Go to 4 or 5.
See, I'm thinking we'll be denied, but I'll have a year to file supplementals, each keeping the intent to file date. No, you don't. That's why whatever you file, that's the only thing that gets that date. When you file something the next day, it gets that date, the next day's date. So that's just another reason you want to file.
Let's just put an example out there. You filed January 1, 2025 on, June 1, 2025, you file your PTSD claim. That one will go back to January. But on the 2nd of June, you file a claim for your back. You win that does not go back. It only goes to the day you filed.
Yes.
Stupid rule. I'm hoping it gets challenged and overthrown, because I think when you file an intent to file, it should include every claim filed within that year. But it is VA doctrine right now that it's only the first claim or claims filed at the same time.
Okay, so what happens is, say I have new claims which are filed on a 526, but I have supplemental claims. These are claims that maybe were filed 10 years ago, 5 years ago, and I filed those on an 0995. I make sure if there's an intent to file in the claim that I file both of those forms on the exact same day, so that all of them get that earlier effective date. Now, I know you're thinking, why would I file for something secondary to a condition I'm not service connected for? 2 reasons. First of all, you've got your claim started. But the second thing is, if somebody awards, say you file for hypertension and you also have chronic kidney disease. If you don't file for chronic kidney disease, they're going to award you for hypertension. And then when you file for chronic kidney disease, they're going to say, oh, that starts the date you filed that appeal, which is not, or that claim, which is not correct. If it's already in there, then you're going to get the earliest effective date. So it doesn't hurt you to file these. It hurts you to not file these. I can't say it enough. If I have to say, the very biggest problem I see is you don't file. File for everything, get it out there. And I am shocked by sometimes the things that I think will get approved don't, but the things that I think won't get approved do. So you don't know what the VA is going to do. Put them all out there and then go with what they do, because that's going to give you the most benefits. With any other question, the same person will handle all of those that are filed at one time.
At one time. There's a work queue, and I don't know how the work queue would be divided up if you have multiple claim streams going or multiple claims in the same kind of area, meaning they're both needing RVSR versus one is a higher level review, or one, obviously one's going to the board, that's a different claim stream. But
the next
go back to what Carol said,
it's like
you kind of understand the medicine here. I mean, you understand how everything's related. So it's not like you're making wild claims. I mean, if you've done your research or you understand this and you see they're all related, get them all in there.
And file the medical articles that show the relationship. Okay. You're going to have examiners say, no, one said there was no relationship between hypertension and strokes, which is, I mean, I wonder where they got their medical degree. And so if you file the medical treatises in there showing this, then you're going to say, look, these are peer-reviewed articles where the brightest brains are saying these are related. Can you show me the reason why you're saying they're not? It gives you something to question an examiner if they're going to say something stupid like that. Okay. I just call it like I see it.
Yeah, today's not a good day for C&P examiners in our view, from what y'all have been showing. Tim, hello, Helen Ponton. I was service connected for sinusitis 30% back in April, which led to 100%. VA assigned an effective date of January 2025, when I actually had a continuous claim going back to PACT Act. I submitted HLR CAR claim asking for review effective date and received a response that there was a duty to assist error, and they're sending it back for a C&P exam reevaluation. Is this how CAR should have been processed? Do I have any options? Yeah. If the C&P decreases rating, will I be required to pay back retro? No, you definitely won't be required to pay back. I don't understand that. Why?
Because maybe he didn't want to have to work on it right then, so they can always send it to a C&P exam, and then they don't have to work on it right then. But B, maybe they're asking them, tell me how it was back when you filed your first claim. But remember, look at get the copy of the C&P exam you had first, and look at what that examiner pointed out as qualifying you for the 100%, and make sure it's clear to this examiner that the condition has not changed. That's the thing that you want to do. And no, you don't have to pay anything back. They granted you this benefits. You're entitled to them. If they change it, it will be in the future, not in the past.
The severance case that Carol and I were talking about with one of the other vets, I don't know what that was, 10 minutes ago, they were saying that wasn't a reduction. That was a severance, to where they're saying that this should never have been granted in the first place, and therefore you owe us the money we gave you. Again,
but that's not the law.
That person should give them the money, but you would be in a different position here, and that if they're reducing you going forward. They're not saying this should have never happened. But yeah, I don't know. I think Carol's right that the optimistic way to look at this is that they want a reading on what the rating should have been back to the beginning of the PACT Act, because that's
like they could really tell.
Yeah. Constitutional immunity 2.0. I have service connection for lumbar and many secondary issues to my body. When I separated 12 years ago, I also went for depression, anxiety, denied. Recently denied again. The depression is real. Why the VA denied 90% if now it's real? I don't know what to tell you there, but we see really bad denials all the time. Having anxiety and depression secondary to spine is a common secondary issue. I mean, frankly, anybody with a bad back is depressed because their way of living, their way of being, the essence of who they are is all significantly changed because they can't do many of the things they used to do. So I would fight that if that's what you're asking for.
And actually, those are ones that are often really approved. I'm kind of surprised. I'd get a copy of the C&P exam, and I would look at it and see if what they wrote down was actually what you said. And if not, I would say, I said I have all of these symptoms and I want a new C&P exam, and not with the person that you had before. I'll bet you anything what they described and the things they talked about may not be anything what you said. And that you put that on a 4103, make sure that, and sign that. That's sworn to.
4103 or 4138?
4108. 4108. I don't know. I don't remember.
Don't trust us on the numbers. Never trust us on the numbers.
We're not numbers people.
Mr. Williams, hello. I was wondering if there are any updates on BVA working on legacy appeals, SSOCs. It's been 10 months since back to board from denial remand.
I thought they had priority, but I am seeing some of them sit there, and I don't know why, but maybe you should file a motion to advance to the docket saying this is legacy and it's supposed to be given priority. I think that's what I would do. And of course, remember, if you're 75 or older, you get automatic advancement on the docket. And I have to say, Matt, you know, they were shooting out BVA decisions right and left. And then I'd say for the last month, it's like, where are these people? You know, I don't know what's going on.
And my thought is that's the ebbs and flows of a summer vacation. They take a lot of vacation right now. But to Carol's point, I think that's a great idea. We're coming up on the end of their fiscal year. October's the end of the year, October 1st, or sorry, September 30th. So this is a pressure month for them. This is a time when we in our office like to poke the bear, frankly, to see if we can get them to make decisions because they have quotas they got to meet and they got to get their decisions in. So this is a great time to do what she said. Hey, what's going on here? Give me an advance on the docket. And if they see a case that hopefully is relatively easy because yours has gone up and down so many times, they take that up. So I think that's a great strategy for right now. Make a doodle. Hello, 1 of 4, 100% PNT, 60 for both hands, rheumatoid arthritis. Do I need to? Oh, I have SMC-M just for that. 40% TMJ, 30% plantar fasciitis tendons. 10% instability right knee, 10 for left, 20 for degenerative joint disease, 20 for left knee, same, 10% flexion, both knees, 20% for left ankle. Now BVA recently granted me SMC-M, VA rated, and gave me N.5. Question now that I'm N.5 without ANA, would I apply, if I would apply for ANA, and if granted, would this be R1?
Why wouldn't you? I mean, really, look at all.
Go back to the first ones he had.
Yeah, 100% for his hands.
60. I mean,
he has M for just that.
He has M for just that. But my question would be, what does he get aid and attendance for besides his hands?
Well, go ahead. You know the next one, Benji. To look at all the things he has.
I mean, I look at his legs, and his legs have to be maxed out due to the amputation rule. I've never seen that many. So right. maybe he should be lost of use of legs. I don't know. I mean, if all those ratings are on your legs, I don't know how you get around without a cane, without crutches or something. So that would be where I would be looking. But you need an aid and attendance that's not the SMC-M for your hands. And
then also remember, if you have anything else we haven't talked about, we go back one again. Like sleep apnea, headaches, any of those things. Remember, that's a way to get a 50% as well. You're almost, it looks like you're almost to O.
I mean, I don't know. That's right. You know what the max for TMJ is? Like if he could bump that or the plantar fasciitis up to 50, then you're right. Then he gets O.
But definitely I'd file for aid and attendance too, because it looks like from your feet alone, the lower body, you would need aid and attendance. But file for all of them.
Yeah. All right, Rick, how much is needed for medical evidence to file a claim for anxiety second to tinnitus? Currently 10% with tinnitus, received a diagnosis of GERD and PTSD last week. Haven't received treatment yet. This is where Carol loves to grab a medical record or a medical treatise or something, right, Carol? I mean, so something shows that tinnitus could cause your depression or your anxiety. That's what I do.
But I think it really helps when you go to the doctor saying tinnitus is driving me crazy. It's all night long. I can't sleep. You know, I can't think. People are talking and I can't hear what they're saying because of the tinnitus. And you need to get that in the record showing that is the cause of that. And then put the medical article in showing, you know, they have medically connected these two. You definitely want to receive treatment. If you don't receive treatment, then the VA will say you don't even have a diagnosis.
First one, good to see you. This is a clarification question that I asked you a few weeks ago. Sorry for the confusion in my initial post. Thanks for your sage advice and wise counsel. Wow, I don't know if we deserve those words, especially when you try to do math. What is my effective date? 2022, I submitted a claim for genetic blood condition that presented during my service as microcytic anemia. After facing multiple denials from VA, I requested my CFIL. Upon review, I found that I had signed a 526 form 1998, but the separation section did not forward the files to the VA until April 01. I remember we talked about this. May 01, I filed a claim for a different condition, not recalling the 98 claim. Now, 2022, I've filed a VA claim for the anemia, which is currently at the BVA. Okay, so one more. Looks like this is 3 or 4. No, 4. So they have this bizarre concept called implicit denial doctrine. So that if you file a claim and it's an open claim, that's what the 526 from 98 is, and there's a subsequent decision on the same or a similar enough issue, then that forecloses that prior claim. From the facts you've given me here, that's an open claim, because right. You said you filed claims for different conditions, but not the anemia. So I think that is open all the way back. Now, the BVA, the sole focus of the BVA here is service connection. The issues of rating and effective date are downstream from that. So the RO is going to get the first crack at the apple at that, and they're going to screw it up. You know, they're not going to. Seriously, that's 27 years of benefits. You can bank on them screwing it up, but if the facts are as you just presented, there are no claims for anemia between that 526 in 98 and a claim you filed in 2022, you have an open claim, and you need to fight for all the way back then. First and foremost, you know, like what we do with our clients, we want them to have benefits now. You know, get your ongoing benefits, okay? Get it service connected, get the rating right, and then fight on the effective date, because you want your current rating to be as high as possible, so you're getting that income coming in. But don't give up on that effective date. Carol,
right. Remember, a lot of times we've had claims like this, and even the BVA denies you. So you go to the Court of Appeal. This is a really good claim. Don't let them deny you and make you go away.
Yeah, because if they deny you and you don't appeal within the appeal period, you're done. Those benefits,
you've given it up.
And yeah, you can't get them back. This is fun. This is the kind of stuff that Carol and I love. So please keep us informed on how this is going. Lonnie, how the regional office updated the language about Berry v. McDonald instead of only one bump up for multiple increases between SMC-L and O. I'm not quite sure what the question is. That they have language in there. And Carol, didn't you say you actually seen the RO start to do this?
Yeah, they've been doing this, and they weren't doing it for a while, but within the last 2 months, I would say they were doing it. And I think they actually have some kind of calculator that they're using. So they're definitely bumping them up. They're not always getting them right, because remember, one of the things about whether you can use another rating is whether or not it was already used for the basic L that you got for aid and attendance. So that's why, even though they have a calculator, it may not be correct, but they are definitely doing this. But we are appealing a lot to the board because they're not right.
Yeah. And I mean, you know, this goes back to what Carol says. Do you mess around in the RO, or you go to the board? You know, the RO is doing this. You get a decision faster. But if you go up to higher level review and they screwed up again, I'd go to the board.
Yeah, and sometimes I'm not even going to the higher level review because it's clear they're not, I don't know why, but they're not changing it, what the board is.
Richard, hello. I just want to thank you both for educating us and answering questions. I was able to get PTSD 100%, migraines 50, 30% for acute sinusitis, and 0 for hyperthyroidism. Wow, that's great.
That is.
I should also be getting SMCS. Yes, you should. Shortly as well. Had to file a claim to remind them of that. Again, thank you for everything. That's Richard. Cheerio to you. Go back.
Makes our day.
Yeah.
This is why we do this.
All right, so Carol's going to want to know if there's anything you need 100% for the PTSD that you might need aid and attendance. So just keep that in the back of your mind. You know, do you ever get lost? Do you ever lose things? Do you leave the stove on? Do you could take your medicine? Because that's one more bump. And you know, as her new saying,
"You served, you deserve." Love it. I want to sign that.
Oh God.
Thank you for that.
Grace, good to see you. ITF 1124, award letter 7/28/25. 40/70 increase. They received 20 years retirement pay, and VA comp received both or one or the other. And how to calculate amount of back pay from 1124.
Can we go back? I'm not sure I understand the question now. Okay, intent to file. Okay, award letter.
So your benefits start December 1st, meaning that if the November doesn't count, it doesn't start till the next month. So if you're looking to count back how many months you're entitled, you should start there. We actually keep on, Benji, can you put up our retro calculator? We actually have a calculator for this to help.
You put number 2 also while we're looking at that?
To help people understand what their retro should be, because again, we suck at math.
70%, 40/70 increase. So receive 20 years retirement pay and VA comp, or one or the other. Oh, so you're getting 70%, you will receive both. But remember, first they're going to send it up to the Department of Defense to make sure there's not an overpayment and to slow down paying you. So initially you will get the award, but you probably wouldn't get much money. And then within the next few months, if it's Army, it'd be pretty soon. If it's Coast Guard, you can wait a year or more. So most of the services are really quick, except for the Coast Guard, which is
your retro might, the calculator won't calculate that because your retro might be off because they're still withholding it till they see that there's no offset. But as Carol said, there shouldn't be, and you should be getting both going forward. All right, JC Jarhead, I was denied service connection, Nexus for GERD, second to PTSD. Will an IMO qualify for new enrollment? Yes. Yes,
absolutely.
Definitely. What other evidence do you recommend I should supply them? Thanks in advance. So that in and of itself goes to the heart of the matter, the nexus.
But I always like to see medical records where you're complaining about the things that GERD creates and talking about how PTSD may have affected it. I mean, those are the things when you go into your doctor, you need to be clear. When I get upset, when I get angry, then I get this, burning sensation, whatever it is that happens to you. Okay. If it's in the records, it really helps.
Jim, does the VBA combine TBI PTSD? What is SMC? She needs to help him with appointments, meds. Should he apply for ANA?
2 questions. Basically, I think, okay, so VBA is, they have, what they have is aid and attendance. And remember the veterans medical section has caretaker. So I think you're talking about she needs to help him with appointments and med. He should apply for aid and attendance, but she should apply for caretaker. When somebody has TBI with PTSD, they're usually pretty profound in the symptoms and problems that this person has. So I think that they should apply for aid and attendance and SMCT, okay? A special monthly compensation due to traumatic brain injury. And then the person should also go to the VA medical facility, not the benefits, and apply for caretaker because of the problems this causes. And yes, they do combine TBI, PTSD.
If the symptoms are the same or they overlap and the doctor can't tell the difference between the two, then they do combine them. But if the symptomatology for the PTSD is different than the TBI, then you should get ratings for both.
So an example is if you have memory concentration, that could be either one, so they combine them. If you have headaches, they get a separate rating. If you have Meniere's disease, say you have dizziness and vertigo, that's a separate rating. So the TBI can be just for the things that it causes for memory, but then also for any physical problems that it causes. And when you say what SMC, we're starting with L for aid and attendance, but then that would automatically give them, that should give them SMCT.
Yeah, because of the TBI. Yeah.
Right.
All right, let's do 2 more questions here. All Night Long 63. Good afternoon. My question is, how do I get a rating for my PTSD, sleep apnea, and prostate cancer? They tested me for all 3, but my ratings haven't changed. I'm currently 40%, but they haven't rated me for sleep apnea, PTSD, or prostate cancer. My first question would be, had they granted you service connection? Had they admitted that these were related to service? Because I think that's probably what's going on here, is they're denying that they're related to service. You might be a Vietnam vet with the PTSD prostate cancer. If that's the case, prostate cancer should be automatically service connected. So I'm not quite sure, and again, with prostate, if it is service connected, but you aren't currently in treatment.
You're in remission.
Yeah, you're in remission. Then what has to be rated is your, not side effects, your residuals. So you need to look at what all, Carol?
Voiding. How do you have to get up at night to go to the bathroom? Are you incontinent? How frequently during the day do you have to go? If it's every hour or less, that's a 40% rating. Also, do you wear pads? If you have to wear pads and change them more than 4 times a day, that's a 60% rating. Also, erectile dysfunction. Have you suffered that because of the prostate cancer? So all of these are residuals, and you need to make sure that you apply for all of them. Plus depression is often, but I guess that would go with the PTSD. You already have that. Matt, I'm not sure whether you're service connected and they haven't rated you. And I have to tell you, it is so infuriating. We'll get the board to grant service connection. I've gotten this for sleep apnea, PTSD, and prostate cancer, and he got 3 zeros. So this is their game. You don't let them get away with it.
And how they win the game is, if they confuse you, you walk away and then come back over a year later and say, okay, this isn't right. Well, so you get it right, but all those retro benefits back to when you applied go away. They keep them.
Yeah.
So I definitely would appeal this. All right, last question. Rich Rod 1678, good to see you. What is the significance of the original control date on VA claim?
I don't know what a control date is. That's more of the VA language.
You're right.
I know the original claim date, that's when you first get paid. That controls unless you file within a year of being discharged, and it should go back to the date you were discharged. But I don't know what the control dates to me are, just when they maybe establish a claim, which may or may not be the date that you filed it.
Well, let's take one more that we actually know. Tom, question. JP4 toxic jet fuel exposure and loud jet noise and delayed onset auditory nerve damage. Any cases 1?
Yep.
Yeah, I would be basing that more on the nerve, the loud jet noise.
Yeah.
Fuel exposure. All right, folks, that's a wrap. Again, if you go to, if you go to Combat Craig's website, you can drop a line about him and stuff he's done for you. And it's unfortunate to see his passing. He's a great actor.
No, I didn't know that.
Yeah, I just passed 2 days ago.
Oh my God.
Yeah, it's awful. But as far as today, thank you again for all your questions. And it's, as far as my winner or what I appreciate the most, there's some great questions, but I think, Darwin, you serve, you got it.
You serve, you deserve. I am so happy for that, because everybody, I say, why didn't you file a claim? Well, they're more deserving than me. There are not. You served, you deserve.
Darwin, that's going to be in my life for the rest of my life. So I just all right, y'all, have a great week, and we look forward to seeing you on this space next week. Be safe this weekend for Labor Day, and thanks for being here and helping us.